Colleagues, thank you very much for joining us this morning. We are honored to have you at our first corporate investigations and white-collar crime event at CDH. CDH has a long history of investigating corporate matters, looking at them from a forensic perspective, but also from a workplace perspective. And having understood what the market requires in terms of high quality, well-presented, and successful investigations, CDH moved to establish a dedicated corporate investigations team. And that's how we find ourselves here, looking at topics that are pertinent to the work that we do. So thank you for honoring us and joining us this morning. We're looking forward to having a very constructive discussion on a topic that really touches on our practical work in investigations from a legal perspective as well, and from a compliance section. And this morning we bring together a panel of speakers who are specialists in their field and are able to touch on the areas of how we handle information in our investigations, how we actually conduct ourselves as investigators, and then how this works for us in a corporate environment. Because at the end of the day, we find ourselves here representing organizations or providing services to organizations. So we look forward to having a really constructive, comprehensive discussion, but it is by no means the end of the topic and how we'll go about it. So because of our limited time, please do not feel that we will do this topic justice. It is something that we will need to continue to discuss over time. Please see this as the beginning of a series of discussions that we will have. But we look forward to really having an interactive discussion today when our speakers have presented to us and we've gone through the process of really tackling some of the high-level topics and going into depth on specific matters. We will then open the floor up to having a discussion. So please get your questions ready. This is a great opportunity, as we have our speakers before us who we will introduce, for us to really interact and drive each other as colleagues who work in this area. So thank you again for joining us. With the understanding of the importance of complying with legislation when it comes to investigations, we looked at POPIA, which is an important topic at this point, not only in South Africa, but from a global perspective when we think about data protection. And we looked at how we bring the issue of POPIA and compliance with POPIA into the sphere of how we do our investigations. And really the aim is to make sure that as investigators, as legal advisors, as risk managers, we understand, one, what our obligations are, but also how to meet those obligations and not leave our organizations in positions where they're open to the risk of very serious fines, which can come from the Office of the Information Regulator. So with that understanding, we want to come together again and have this discussion really from a point of giving feedback from the practical side in terms of how we find it as we are the investigators, but also getting information from the chairperson of the Information Regulator, our senior manager who's joined us, so we can also understand what the expectation is on us as we are in our environments. So thank you again to our speakers who are before us. Thank you for joining us and giving us of your time. And I'm just going to take time to introduce each of our speakers this morning. We are joined by the chairperson of the Office of the Information Regulator, Advocate Pansy Tlakula. Advocate Tlakula studied a Bachelor of Laws and an LLB. And I know she's not keen for us to go into those things, but I think that foundation is very important so we can understand just the gravitas of the person who is before us today. She also completed a master's, her LLM, at the Harvard University. She holds a doctorate of legal studies, an honorary doctorate from the Vaal University of Technology. I'm sure we're all aware of the influential positions that she has held. And these include being a member of the Human Rights Commission from 1995 to 2002. She was appointed as the Chief Electoral Officer of the Electoral Commission of South Africa in 2002 until 2011. In 2011, she was appointed as the Chairperson of the Electoral Commission until 2014. She was appointed in 2005 as a member of the African Commission on Human, and she has held many, many positions. And we are privileged to have her as the chairperson of the Office of the Information Regulator. As I mentioned, we find ourselves where we are at a point of global interest when it comes to information. So the office of the chairperson requires someone who has the experience that Advocate Tlakula has, but someone who's able to drive the mandate of POPIA forward. And as we've been keeping up with the progress of POPIA, we've seen her take it from an office that did not exist, that existed on paper, to becoming a practical office. And I was listening to an interview you did, I think a few years ago, chairperson, where there were no staff at the office, to an office that is fully staffed now. And in recent months, last month, we had a complete feedback on matters that have been raised with the Office of the Information Regulator. So, Chairperson Tlakula, thank you very much for joining us today. We look forward to hearing from you. And it is important for us to hear from the proverbial horse's mouth when it comes to this matter and how we deal with information. So thank you for joining us. We are joined by Advocate Nosipho Zikishe, who is a Senior Manager, Complaints and Investigations at the Office of the Information Regulator. Advocate Zikishe is, in her current role, manages strategic functions in the division by fully providing support to the executive POPIA in respect of complaints and investigations. Before joining the Information Regulator in January 2023, she was in-house legal counsel and head of regulatory compliance of the Credit Bureau at the National Credit Regulator, where she provided strategic regulatory legal services and also provided support in terms of commercial law, data protection, complaints, and investigations. She also looked at dispute resolution, legal compliance, corporate governance, risk, and consumer credit law. Now, in her coming with this experience to the Office of the Information Regulator, we have someone who understands, one, compliance when it comes to laws. So she is now placed in the Office of the Executive of POPIA. And this is really important from an interaction perspective for us as people who deal with POPIA and have to deal with investigations specifically. She then brings the experience based on where she has come from in terms of how the practical application of POPIA would work for us in the areas that we are in. Thank you very much for joining us this morning. As investigators and persons who are tasked with investigations, the global standard is set by the Association of Certified Fraud Examiners. This is an international body which brings investigators who look at commercial crime, fraud, and internal corporate matters together and sets the standard in terms of how we need to conduct ourselves when it comes to investigations. We are honored to have Ms. Roxanne Ferreira, who is the head of operations at the ACFE, joining us this morning. Roxanne is a certified fraud examiner, and she recently joined the ACFE as head of operations. She's an experienced fraud risk management professional with a passion for ethics. She has worked across various spheres of business, including risk, integrity, business management, learning and development, project management, and strategy, with a prominent focus on fraud prevention. She was employed by the Special Investigating Unit, where she was responsible for internal investigation functions as part of the organization's fraud prevention and response strategy. At the ACFE, she is part of the team that is coordinating the development of the POPIA guidelines for certified fraud examiners and investigators. And we look forward to hearing about how the ACFE is dealing with this matter, as they have really moved forward and are ahead of a lot of sectors in looking at how POPI should be implemented by its members. Roxanne lectured on strategic management and organizational development at the Tshwane University of Technology. She holds a master's degree in workplace ethics, as well as a master's degree in business administration. Roxanne, we look forward to hearing about the work that the ACFE is doing in light of POPI, and really looking at how we go forward as the people who must investigate and how we can comply. But I think most importantly, as you are here as well, and we have the chairperson of the information regulator, we want to see how we bring the ACFE together with the Office of the Information Regulator to make sure that compliance is what it needs to be. So thank you very much for joining us. So as we come here today, the majority of us represent organizations. We come, as I said, in our different capacities, in our different roles. At the end of the day, when we are tasked with workplace investigations, we need to ensure that the investigations are conducted in compliance with all of the legislative requirements, regulatory requirements, but we deal with people at the end of the day. We're dealing with employees who are in the organization. So it's important for us, when we look at this topic, to think about how we then see employment law, what the obligations are upon us as investigators, as legal representatives, to ensure that we have protected the rights of employees while meeting the mandates that our employers give us. So with this in mind, we are very privileged to have one of the top authorities when it comes to employment law in South Africa and beyond our borders as well. And he happens to be a CDH representative as well. We have Mr. Adil Patel, and Adil is the practice head and director of employment law at CDH. Adil is the head of the practice, and he is known as a thought leader in his field, and he is recognized for his in-depth expertise in employment law, and has acted extensively for various employers in both the private and the public sector. Adil has worked across many jurisdictions in Africa and globally. He has presented a wide range of legal topics to different audiences and is featured frequently in articles and is sought after as a guest speaker based on his expertise. Recognized by both his peers and clients for his proficiency at employment law, Adil's track record includes having successfully advised and represented a number of state-owned enterprises as well as companies that are listed on the JSE and with other employers. It is key for us to have Adil here as he has a particular interest in POPIA, and he will speak to us on a very specific area that very often we forget and may not think of when we are conducting our investigations. Investigations are very important for us from a proactive mandate perspective, but there is a result that needs to be attained by our employers and the persons who task us. And this really comes into our post-investigative work. So it is all well and good for us to investigate, but if the work that we do, the reports that we produce, can then not be used by employers or by those who have mandated us, it becomes a real challenge. So Adil is going to speak to us about how we should be thinking, about how we go and investigate with that post-investigative perspective in mind, to make sure that we have complied, again with POPIA, to the point that we will not have challenges when we get to the post-investigative stage. So thank you very much to our speakers. We look forward to hearing from you today. And I would like to invite the chairperson of the Information Regulator to come up and give us an opening address. We will then go into our discussion with our panel thereafter. Thank you.
Good morning.
Good morning.
Abshin. Dumelang. Tendai broke our pact because we had a nice chat that she shouldn't do what she has just done. And I have a witness because when I told her there was someone next to us, because I told her that I'm not looking for a job. So my CV doesn't matter anymore. All that you have to remember is that I'm a grandmother of 2 children. That's all that matters at this point. Thank you very much for inviting me this morning. It's an absolute pleasure and delight to be here. But I think that compliance with POPIA starts with small things. Let me tell you what I've observed. I see there's a person who's taking photographs in this room. And no one has asked for my permission whether my photograph should be taken. And I know you are recording the proceedings as well. So probably in order to comply, when people register, you must just have a note to say if you object to your photograph being taken, please. Say, please note that photographs may be taken at this event, and if you don't object, if you object to your photograph being taken, please say so. Or if you don't do it at that time, please, before a person photographs you, says, do you mind? You know what I mean? But I mean, we learn, POPIA is new, isn't it? So that's the spirit with which we're looking at it, that it's a new piece of legislation. I was just asked to just give a general overview of where we have been and where we're going. But the first thing to say, I think, for you as investigators is that there is a fear out there that the Protection of Personal Information Act prevents or hinders people from doing their work. And that's not the case. All that the Act says is that if in doing your work you're going to be processing personal information, ensure that you comply with the 8 conditions for the processing of personal information. And within those conditions, there are inbuilt exceptions. There's an exception of, for instance, processing personal information for conducting an investigation of an offense. I mean, just to give an example, that in such situation, you can't, when you are investigating an offense and you are investigating me, you then come to me as a police officer and says, oh, please, can you consent to us? I mean, it's ridiculous. It can be, so consent is not required. So if you look at it in that manner, of course, you'll find that it's very easy to comply. Of course, there are intricacies of interpretation. It's new. Sometimes the Act is also ambiguous in terms of how certain sections have been drafted. I think the most difficult part that all of us as regulators of personal information are going to be confronted with is in the AI space, and I don't even want to go there. With the chat GPT and everything that is happening, generative artificial intelligence, if you look at all those things that are happening, disinformation, deepfake. I was watching yesterday online, a video which was supposed to have been former President Obama. And when I looked at it properly, I said, this is not Obama. But the way they have perfected the AI, you have to struggle to check whether it's him or not. And going into elections in 2024 with 90 countries that are having elections globally with disinformation, you can imagine they can just generate President Ramaphosa and put him there and saying the strangest of things, and us thinking that it's him when it's not him. So this is the challenge that we regulators are faced with globally on whether we'll be able to regulate AI. Are we equipped? I don't think so. So it's been a long road for the regulators since the 1st of December 2016 when we met for the first time in a boardroom in Pretoria at the Department of Justice, 5 members. We had never met each other. And we were told that we have to establish the regulator. All that we had was the legislation. We didn't even have a booklet. We had to download it from the internet. And we looked at each other and said, what are we supposed to do? And that was the beginning of a very exciting journey. And fast forward 2023, we have an office in Braamfontein. We have the chief executive officer. We have executives in 5 divisions, and we have 100 staff members. And we attained that in 6 years. And it's not easy to establish an organization that does not exist. So, having said that, how did we start? We started by adopting standard setting documents. And if you go into our website, you'll find that. For those of you who are processing personal information that requires prior authorization, you have to apply to the regulator. And until you get that authorization, you have to stop processing. So we adopted a guidance note on processing of applications for prior authorization, guidance note on processing of special personal information, also processing of personal information of children, so that we guide, responsible parties if they want to put an application for the processing of those kinds of personal information, and those who also want to apply for exemptions from one or all the conditions for lawful processing of personal information, because POPIA also allows you to do that. If, for instance, you process personal information relating to national security, you can come to the regulator and apply for exemption from all the conditions for lawful processing, or for some of them. So we also did a guidance note for that. And then we also did a guideline for codes of conduct, because as you know, in terms of the Act, responsible parties or entities who process certain kinds of information, let me say specified bodies, specific bodies can apply for a code of conduct. In that code of conduct, they will say how they are going to process personal information. They will also say that this is how we are going to be investigating complaints internally relating to the violation of the code. And the code has to also provide for an adjudicator to whom a complaint can be made if there is non-compliance. So we have developed a guideline for issuing of a code of conduct. We're not in the business of issuing codes of conduct like that, because that's a heavy responsibility, because if we issue you with a code of conduct, we are actually sort of delegating our power to you to say, you yourselves as a body, this is how you are going to be processing personal information, and this is action that you are going to be taking if your code is not abided with. But even then, if that code is not abided with, then a data subject can still come and complain to the regulator. So we have only issued 2 codes of conduct. We have rejected many. We have issued one for the Banking Association of South Africa. We have issued one for the Credit Bureau Association, and even those, we had to return the applications 3 times because we felt that they were not compliant with the guideline for the issuing of the code of conduct. The guideline for the issuing of a code of conduct is binding, so you have, before you submit a code of conduct, you have to ensure that your code complies with every aspect of the guidelines. So we make a distinction between a guideline and a guidance note. A guidance note is that, it's not binding. We just guiding you on how to apply for whatever you want to apply for to the regulator. So I was also asked to tell you about the highlights. So far, what is it? I think the enforcement committee, the establishment of the enforcement committee has been the highlight, because it took us a long time to reach that point. Because the enforcement committee, as you know, what happens, and you always have to remember that we are responsible for both the Protection of Personal Information Act and for POPIA. And those of you who are information officers here, you must know that the days of ignoring requests for personal information, requests for access to information are gone. Because with the Human Rights Commission, when they were regulating POPIA, there were no consequences for non-compliance. Those days are over. Because the Enforcement Committee deals with both POPIA and POPIA complaints. And in POPIA, unfortunately, the information officer is the one who takes responsibility. If there is a criminal offense that has to be investigated for non-compliance, it will be against the information officer. Those of you who are information officers here, you really have to ensure that you comply. So the enforcement committee is made up of outside members. It's chaired by Advocate Helen Fourie, who is senior counsel. And one of the members of the enforcement committee, of course, has to be a member of the regulator, and we rotate. And the enforcement committee is very busy. It is sitting. It has now issued how many recommendations? How many? The ones that we've dealt, you'd know better. I think 5 or so. They've issued 5 recommendations, both on POPIA and POPIA. How they work, the division investigates a matter, compiles a report which will have preliminary findings and preliminary recommendations, and the investigation report goes to the enforcement committee. The enforcement committee looks at that report that comes from the investigators. The enforcement committee has wide powers. It can decide the matter on the papers. It can call documents. It can summon people. It can do whatever it wants to do to investigate, to look at the investigation report. Thereafter, the enforcement committee then writes a report with recommendations and findings, and they submit that report to the members of the regulator. The members of the regulator then looks at the report of the enforcement committee, and after considering that report, the members write what we call an enforcement notice. It is in that enforcement notice where the members of the regulator are going to make a finding of the provisions that of the POPIA or POPIA that have been violated. And then it will, I'll not talk about POPIA because a little bit, I'll take a long time. Let's confine this to POPIA. It will be then, the enforcement notice will give will highlight the provisions of POPIA that have been violated. It will also give reasons why those sections have been violated. And then the enforcement notice will also give, it's not a recommendation this far, it will then be steps that have to be taken by the responsible party to correct the violation. Or or it can also say that they must stop doing certain things. And that has to be performed within a particular, the notice will give the responsible party time frames within which to take the steps that are stipulated in the enforcement notice. The enforcement notice is important because failure to comply with the enforcement notice within the time indicated in that notice is a criminal offense. So you can't ignore the enforcement notice. You have to comply with it. You can avoid complying with it if you take it on review. The Act uses the word appeal, that the enforcement notice can be appealed against. I don't think so. And I think, Mr. Patel, it is, I think that's I don't think it's correct to take the decision of the information regulator on appeal. It must have been, I'm sure they meant on review. So the only time that you cannot comply if you give us notice that you are taking the matter on review. But if you fail to comply within the time frame in the enforcement notice, then we issue an infringement notice. And that is where now things become exciting, because now we have 10 million up to where we can issue an administrative fine of 10 million, 10 years imprisonment. But there is a loophole that I have seen which I don't like, because responsible parties can then also choose that I'm not going to pay the fine. You better prosecute me. And with, with everything that happens in the law enforcement space, I don't know if we'll see any prosecution. I don't think any prosecution will see the light of day. I'm not giving you tips on how to avoid compliance, but I think it's something that we have to look at going forward in terms of amending the law, because if that's what it is, I don't think we'll be able to effectively implement this law. The GDPR in Europe, once they have found that you have violated the GDPR, they fine you. There is no compliance period that they give you. So I think there is a weakness in this act, and I saw in one of the media, people were telling me that Tlakula has not issued a single fine. And I don't know why they think it's me. They say it like, they think the regulator is me. I'm not the regulator. We can't issue fines because of the way that the Act has been drafted. So that's where we are, because I was told to do this, and later on, we are now going to talk about the balance between access to information and protection of personal information. And I was also, because I follow instructions. So the instructions was that what I've done now was just to say what we've done in the organization from the establishment. I've done that. So second time I'm going around, I'm going to be doing balance between access to information and protection of personal information, and also key lessons from the findings of the Krugersdorp matter. Yesterday we issued an enforcement notice against the Department of Justice. Some of you might have seen it. We'll talk about that as well because it's also quite exciting. Thank you very much for your attention.
It is good to see how the office has progressed and a lot of work that's gone into it for us to be here and now see the Act being implemented and actually seeing where the loopholes are. I think very often you only get to see the loopholes when it's time to apply that part of the Act. So that means it's being applied, it's in action, and the reason we are here is because it has a direct impact on the work that we have. So thank you very much for giving us those insights. Nosipho, I'm going to come to you, and we're going to talk about just really the practicalities of the office that you occupy and working specifically with POPIA and looking at the complaints, looking at the investigations. So I'm just going to hand over to you to give us some insights from where you sit and how that is going and what we need to be aware of as investigators. Thank you.
Thank you so much, Tendai, and good morning to the colleagues. I'm also going to do exactly what I've been instructed to do. I'm not going to go off balance. So you've posed 3 questions, which are obviously related to the topic that you've just, or question that you've just unpacked. So the first one, you've said that information officers are appointed to ensure that organizations comply with the requirements of POPIA. The focus on the information that employees bring to the workplace, which is personal information. Are they considered to be data subjects? And when the employees use this personal information to initiate investigations, what aspects of the requirements of POPIA are very important? So obviously the statement / question is correct. The employees in the organization that they're employed in are considered to be data subjects. Personal information is defined in Section 1 of the POPIA, which includes employment information. So it could be the past employment history, the present employment history, the qualifications that got them into the current workplace. So in terms of Section 1, it is personal information. So the POPIA applies to that specific information, which the employers hold within their databases. So this is an interesting topic because we do get complaints around investigations in the workplace. Obviously, I will just highlight what type of complaints we receive as the information regulator. We all know that complainants do not divulge further information when they lodge complaints. So they just give you shorthand information. So you need to investigate. So in terms of the Act, we are empowered to receive these complaints. And in terms of the Act, then we are required to take specific actions. And based on the assessment that we will do, pre-investigation assessment, we obviously would require more details from the responsible party. So we will then write a notice to the employer who's being complained about, who is the responsible party. And the complaint, I'll just use one random example. I've been dismissed and my employer had went as far as investigating my previous employment circumstances. I've been employed for 2 months, and based on that, I'm now called to a disciplinary hearing, and now dismissed. Okay, so the circumstances of the complaint are a bit sketchy. So obviously there is information that the complainant was not forthcoming with. So we will then send the notice and give the responsible party, the employer, an ample opportunity in terms of our rules and procedures of handling a complaint. We give the responsible parties 21 days to respond to the allegations. The rules of procedures of handling a complaint by the information regulator is contained in our website. Then you can just familiarize yourselves as information officers as well. We will afford you 21 days to respond. The response will come in, and it will obviously now bring a much bigger landscape to work with. So you would, the circumstances would be that the employer was obviously conducting credential updates and found out that there was some information that the data subject did not disclose at the time when they concluded the employment contract with a recent employer. And you would note in terms of those employment contracts, it is obviously subject to your credentials having been looked into. So we will obviously then assess that complaint. In terms of the Act now, we need to come back and apply the Act to the set of circumstances. Having to apply the Act to those circumstances. There was no consent required to be obtained from the data subject, which is the employee. And because in terms of the Act, Section 11 FD, if I could be specific, requires that the employer can pursue their legitimate interest. It's within their legitimate interest to pursue such investigations, therefore consent is not needed. And then you go back, because that Section 11 has a general rule and then it has exceptions. So you need to go back, and the general rule is that you need to have consent. The exceptions are the ones that are contained in 11 up to, I think, F. So it's a legitimate interest. It is to pursue the rights of the responsible party in terms of a contract. And which contract is that? It is the employment contract. So we go as far as also requesting, I think, the employer will just, for our sake, give us the employment contract. That clause is definitely, certainly there. So those are the complaints we would receive. So I think that will answer your question. I'll just pause there for now.
Thank you. Thank you very much for that insight, Nosipho. I think we really make it practical now with what we're dealing with on a day-to-day basis. We need to investigate. We're looking at our employees. We've been, again, mandated by the organization, but what are we looking at when it comes to a complaint? And it goes to the Office of the Information Regulator. So thank you for giving us that process, because that understanding is required when the response is then needed from the investigator to the complaint that comes. And can I just ask, before we move on, we'll come back to the other questions. When it comes to compliance, what are we seeing from the employer's side? So when these complaints come from the employees, are we finding that as employers, we are actually responding to these complaints? Or are we at a point where there is no fear, if I can call it that, from employer's side, so we're not seeing a response in the 21 days?
I will not speak on general terms of this, but what we have seen is that we do get responses from the employers.
Okay.
Obviously, it is true. I think there's more interests to guard other than responding to the information regulator as well. I think the process is ironed out quite clearly. We do get responses from a more organizational perspective, the organized entities, if I may say.
Can I just come in to clarify just
Yes.
something here? You asked the question, who's the data subject? You must not forget that the POPIA also says a juristic person can be a data subject.
Yes.
You shouldn't forget that as well.
Yes.
And then in this scenario that he has given, we need to look at pre-employment and and investigations during employment. For instance, if you are verifying, credentials or qualifications of a prospective employee, a person who has applied for a job, you need to get their consent for you to go and verify their qualifications. And you have to be specific on, what you want to do. If you want to go into their Facebook or social media accounts, you have to say, give consent to the following: verification of a qualification, criminal record, social media, accounts. So you can't ask for consent for verifying qualifications and go into Facebook or social media accounts. So I just wanted to clarify, because you will have to look at requirements before employment and investigations for misconduct when the data subject is now employed.
Thank you. Thank you very much for that clarity. I think it's important, again, from our practical perspective. So when we're looking at the pre-employment side, different set of rules to when we are then governed by the contract, the employment contract, as you said, Nosipho. So thank you very much for that. So I think we're going to come now to our investigators. We've heard from the Office of the Information Regulator. We understand how complaints are taken forward. Now we want to look at ourselves as investigators, the challenges that we may be facing, what we are looking at. And as I explained earlier, we are represented, and we have feedback coming from the Association of Certified Fraud Examiners. So Roxanne, I'm going to hand over to you and just allow you to speak to us from the voice of CFEs and persons who are investigators, but not necessarily members of the body, but who would follow the same methodologies, processes when it comes to investigations. Thank you.
Thank you, Tendai. Good morning, ladies and gentlemen. I think I must start with just explaining a little bit about the ACFE, the Association of Certified Fraud Examiners, who we are and what we do. So the ACFE is the largest anti-fraud organization and premier provider of anti-fraud training and education in the world. We have more than 90,000 members who are situated in approximately 180 countries. The head office is in Texas, in America, and then there are 195 different chapters in 76 countries. So we are basically all over the world. The mission of the ACFE is to reduce the incidence of fraud and white-collar crime, and to also assist membership in the detection and deterrence thereof. The South Africa chapter was established in 1998, which means that this year we are 25 years old. We are a registered professional body with the South African Qualifications Authority, SAQA, and we are governed by the National Qualification Framework Act, the NQF Act, as well as the chapter bylaws. Now, we have more than 6,000 individual members, and that includes certified fraud examiners as well as associate members and affiliate members. And our members are governed and regulated by very strict international code of ethics and professional standards, which means that they can be held liable, responsible and accountable for their actions, and also be disciplined if there is anything that goes wrong in those aspects. Our members are from a lot of different industries, for instance, the banking industry, insurance industry, mining, telecommunications, anywhere where you will find fraud examiners, and that is basically all the industries, including the public sector. It's also important to remember that crime takes place in a multidisciplinary environment. I'm going to give an example, and this is a hypothetical example, of fraud that can take place in the insurance industry. A criminal can, for instance, create a fictitious person, take out a policy on this person's life, then this person passes away, and the criminal claims from the insurance company. So in this case, it's not only the insurance industry that is involved, but also the banking industry, because a fictitious bank account would probably have been opened, as well as Home Affairs, because there would either have been identity fraud, or there would have been a fraudulent ID document, as well as a fraudulent death certificate. Another very interesting example is a very recent investigation that was done and aired by Al Jazeera. Maybe some of you have seen it. It is about the gold mafia. What happened here is that dirty money was converted into gold and diamonds and then smuggled out of the country, in this case to Dubai, where the gold was melted. And the moment when the gold is melted, then there is no way to detect the origin of the gold. And by the way, this is apparently the best way to launder money. And I'm also not giving you any tips. This happened in Zimbabwe, but if we draw this back to the South African context, we will see that the mining industry would have been involved, as well as the jewelry industry, banking industry, foreign affairs, home affairs, SARS. So you can see that there are quite a lot of different entities involved in one crime. So the reason why I am telling you about these examples is to illustrate the importance for investigators to talk to each other and to share information. If somebody in one of these sectors get the idea that something isn't right, they will have to talk to people in the other industries as well, and in the process necessarily also share information. Now, that is why people and our members reached out to the ACFE to provide them with some guidance on what they may and may not do. And that is why we opted to develop the guidelines. So the process that we followed, we appointed consultants, and they consulted quite widely, not only with ACFE members, but also with other members in the anti-fraud industry. And they did this through consultation sessions as well as surveys. They then drafted the first draft, which is a very rough draft of the guidelines. And this draft was then sent out to members of the ACFE who are basically in the evaluation committee or drafting committee to review the first draft and to give their inputs and ask questions and so on. This is where we are at the moment with this process. So after we've received the inputs from the drafting committee, that will be included into the draft document, and then it will be distributed to our wider membership, who will also give their inputs. And from there, the consultants will then develop the final draft, which will then be discussed with the information regulator. There will be in-depth consultation, and then only after that has been finalized, the guidelines will be able to be distributed. So we realize that the POPIA Act does make provision for sharing information, but the fraud examiners need to be protected and they need to know what they can and they cannot do. And that is one of the challenges. They have a real big fear of not knowing what they can share with other people who are involved in these complex investigations. And as I've hopefully been able to demonstrate to you, there are quite a lot of entities involved in these complex investigations. Another challenge, and from the survey that has been done, the biggest challenge, and that it came out at 56% on the survey, is that people are using the POPIA Act as an excuse not to share their information. Even to members from the police who are supposed to be exempted, and I know that about the Krugersdorp matter, etc., but they are supposed to be exempted from the POPIA Act. Even if they ask for information, there are still people who say, but I cannot give it to you, I'm protected by the POPIA Act. So that is our number one challenge. The second one, at 26% or 28% on the survey, is the question about what can be shared and with whom it can be shared. Now, everybody in South Africa has an obligation to fight crime. And that includes the ACFE and our members. It also includes the information regulator. And it is our wish and our desire to take hands with the information regulator so that together we can come to a solution on how to fight crime and overcome these challenges. Thank you.
Thank you very much, Roxanne. I think just to really pick up on those key challenges that you raised, and we'll come to the questions and just understanding who we can share information with, how that information can be shared, and whether exemptions exist. Because one of the things that's happening is that in our work environments, we are approached by law enforcement. And the communication we will receive is that we're obliged to provide them with everything that we have. And that clarity is required now when we know that, for example, financial information is considered personal information. We need the clarity as investigators to know what we can then share and what we can't share. But we will come to that when we get there. So Nozipo raised issues around the employment questions that come, the complaints that come from employees. And we're going to hone in on the workplace. Again, as we said, we represent our organizations. We're dealing with employees, whether it's in investigations or doing verifications that are required. Adil, we're going to come to you and just get your perspective in dealing with matters that have to do with POPIA and really highlighting what you find as an expert in this field as the main pressure points that we are dealing with in our environments.
Thank you. So I notice no one claps when I talk, so... And I noticed that on 2 occasions. And the other thing is that I am photogenic, so please take as many photographs as possible. Can I say I operate on the premise that South African employment law is not overregulated. We must get rid of this narrative that South African employment law prevents employment. Our courts have held that what has come about is a kitchen industry of lawyers and consultants who have attempted to overregulate employment law, and thereby ensuring that it becomes exceptionally difficult to deal with employees who are recalcitrant, who are crooks. Now, a term that's phrased within the department, in our department and generally in South Africa is we need to decriminalize employment law. Our courts have held that we treat employment law in the same way that we deal with a criminal trial, and that's why every media report says South Africa is not conducive to employment. It's because of us, each one of us are responsible for that. Now, what does this have to do with the information regulator and the fraud preventers? In fact, I should just be keeping quiet because I'm honored to share a platform with the information regulator and especially the chairperson. I'm certainly not going to get into the legality of it, but I'm going to just tell you what challenges you're going to face. South Africa has a high unemployment rate. We're facing a potential recession. To find employment in this country across race and gender is exceptionally difficult. People are experiencing mental health issues. So when people have employment, they hang on to it for dear life. So try and discipline an employee, they're going to fight you tooth and nail. So let me give you a story, and it's a bedtime story that I tell my daughter, and it emanates from the labor court. So an employee in the public sector is disciplined. The first thing the attorney does is ask for requests for further particulars. What is that? The charge sheet is unclear. So they buy some time. After that is done, the employee asks, I want to be legally represented. Then suddenly the employee becomes ill. And they give you a doctor's note. And you say, but what is this? And then they ill again because of depression or anxiety. Everyone gets depressed when they're disciplined. And I'm not undermining that. And what I'm saying to you are the words of the labor court. Discipline brings about anxiety. You're going to lose your job, potentially lose your job in a country that has a high unemployment rate. And the matter goes on for 2 years in the public sector. And I'm using the public sector as an example because it happens in the private sector as well. Why? Because of this kitchen industry. So what does the employer do as a response? And the courts have caught up to it because we're 25, 26 years into democracy. You bring a sick note, we want the doctor to come and testify. So the sick note is not just valid on its own, because we know what you want to do. You've committed, and I'm going to link it up to the Protection of Personal Information Act. You stole money, we're going to lodge a civil claim against you. That's the employer's response, because it has so few levers at the moment, because of this kitchen industry that the courts have spoken about, because we've overregulated our employment and affected the brand of our country and our own brands. In terms of PRECA, we then lodge a criminal claim. But what does the employee do to fight us? Because they need to hang on to our employment. They know they need to protect. Your brand is more important. So what do? They go on Twitter. They go on Facebook. They lodge an unfair labor practice claim on the basis of suspension. They go to the labor court on an urgent basis. You're spending money on us, and we're expensive. Law is expensive. Now let me tell you what's going to happen now with the Protection of Personal Information Act. Can you see what's going to happen? They need to protect their employment. So what are they going to do? The minute you charge them, they're going to lodge a complaint with the information regulator. You've heard from the information regulator who already told you that they've received a complaint to say, listen to me, You looked at my credentials without my permission. That's the new fight. The chairperson has told you that no longer are you going to be able to ignore them. I have my own views about how do you enforce from a criminal sanction perspective, and we can have a debate about that. What do you need to do? And now this is a marketing speech. We try, right? The information regulators there, the fraud examiners, we have to try. You need to decriminalize your employment arena. You need to tighten up your policies. You need to tighten up your employment contract, because there's a circle from an employment regime where the Protection of Personal Information Act touches on every level. And you need to understand at the principal level, when you get a complaint to the information regulator, are you just going to back off, or is it something that you're going to fight? Because every single employee, like they've done at the labor court, like they've done at the CCMA, like they've done with the medical health professionals, they give you medical certificates. I've got anxiety, I've got a stomach ache. My wife's a doctor. I say, but why don't you say what's wrong with the person? They say, no, we can't. This is the new frontier. And if the information officers, together with HR and together with the legal department, and most importantly, with your communications and brand people, don't tighten up, you're going to find it more difficult to discipline employees. And my final comment in the last minute that I have is, we really, as the employment department, implore you to stop treating discipline as a criminal trial, decriminalize it, so when the employment arena, so when the information regulator gets the complaint, you're not sitting and paying an employee for 18 months and having to defend still. Because you know what's going to happen? They're going to say to you the following. I got 30 seconds. They're going to say the following to you. You see, you're not treating me fairly. You see, in South Africa, we lodge complaints to the information regulator, but the employer still dismisses us. There's no prohibition to dismiss somebody when they lodge the claim to the information regulator. There's no prohibition to dismiss somebody that stole or is negligent, who's lodged a claim of an unfair labor practice to the CCM. And I come across harsh because this is the problem. I understand employers do act unfairly. We must accept that at the process level and at the substantive level. But operate on the assumption that we operate fairly. I'm saying to you that the new frontier of defense is the information regulator. And they can only deal with the information that they have. So when you respond comprehensively. But you got to train your people. You got the information regulator, HR, legal, and your communications people must work together. And you can't ignore the information regulator, because that's the new frontier of attack. Thank you. Thanks. Thank you for the clap.
Adil, thank you very much. You've taken us, I think, to an area that we haven't given enough thought. And as you said, it is a new frontier. It's something that we now need to grapple with. And as I said in the beginning, we need to think about our post-investigation processes. So what we've found with our speakers and the process we've taken now is we started with our act, understood what's happening from the Information Regulator Office. We've gone through to our investigation complaints that are going through to the office. We've spoken as investigators about the challenges that we're facing in terms of getting information. And then we come to our workplace, and we've understood that from an employment perspective, our contracts have to be clear. But our contracts can only be clear if our policies are clear. So the challenge for all of us at this point is to go back and look at our policy regime. As Adil said, It's not a one-person issue in the work environment. It's legal, it's HR, it's your investigation department, which may sit in your internal audit or may be separate. It's everyone working together with the understanding of, one, what the Act requires, but two, how to successfully investigate and ensure that when those post-investigation processes do happen, if any complaints are laid with the Office of the Information Regulator, the organization is able to deal with those. And I'm going to come to you, Adil, and then we'll come back to information. So from a contract and policy perspective, and really bringing in POPIA and understanding what needs to be there, do you believe, from your experience, that our current employers really fully understand how to translate POPIA into a work contract? So is there an understanding of what the requirements would be to get to a point, as you said, when you can then defend, if you get there, have a comprehensive defense? Are our contracts robust enough to deal with the challenges?
Must ask the chairperson.
We're going to start with you. We'll come to the chairperson.
Because I want to just listen to the chairperson. Look, can I just say the following, is that you need to be doing an audit. And the chairperson has given you free legal advice, which you wouldn't get from us, right? She says to you the following: pre and post-employment. Usually, what does your pre-employment say? When you come, you must have a consent form. When you come into the recruitment, during the interview, when you submit your CV, your advert must say, please look at this here because we are going to assess your social media. So your advert must say that. When you come in to the interview, the person must remind you and somebody must record it. We are going to ask you personal information. So what am I saying to you? Because the legislation is new and it's commendable what the regulator has done, you need to be conservative because we're all learning. But in the area of being conservative, what does that mean? Doesn't mean you can't discipline people and fire people. It simply means you got to get your house in order. And the chairperson has clearly indicated to you what you need to do. So to answer Tendai's legal question, it's not. We're seeing that more and more often. And I'm concerned that we're having to fight for employers at the information regulator all the time. Because when we get this letter, it's panic mode. Why? Because it affects your brand. Imagine the information regulator tells you whether there's a finding or not is irrelevant. The fact that you've been reported to the information regulator affects your brand sufficiently. It's like telling you or telling somebody that they are a harasser in terms of their harasser code. Or where the SIU comes and says that there's an allegation that you've taken TERS funds. The mere allegation in South Africa has the potential to materially impact upon you. So that's why you need your communications people, and that's why when you submit your information to the regulator, it is as comprehensive as possible, because when the media comes, you can say, but what are you talking about? Thank you.
Thank you very much, Adil. Thank you for that. Chairperson, the challenges that investigators face. So we are faced with organizations, law enforcement agencies coming to us and saying to us, you are obliged to give us information of your employees or people who you are working with, any investigations that you've conducted. Very often we are then told that by virtue of their office, they do not need to get subpoenas, they do not need to get court orders for what would be considered personal information. And I'll use financial information, for example, of individuals. What is the position when we sit as investigators, when we sit in our organizations, and we find law enforcement coming and requesting this information and saying we must give it to them?
You know, that depends on how we interpret. And as Ms. Patel has said, this is all new. So all of us, we sort of struggle with interpretation sometimes, because what you are talking about is what is called further processing of personal information, which we'll find in 15. And further processing is not allowed, which means you cannot share. But like every section of POPIA, there is an exception. Now, the exception says that further processing can be allowed if the further processing is necessary to avoid prejudice to the maintenance of law by any public body, including the prevention, detection, investigation, and prosecution. I'm not sure that police can come to you and request you to share personal information of employees without even a warrant. Or I don't think that section, that's my interpretation. I don't think that section allows them to do that. Before POPIA, when I was still with the IEC, the police, SARS, everyone used to come to say, bring the voters roll with addresses who are looking for X, Y, and Z. And at that time, I refused. And POPIA was not there. I said, this voters roll, people gave us their permission, their information for the purpose of voting, and not for law enforcement purposes. So my guarded response is that I don't think that further processing is allowed. You must refuse.
Thank you for that clarity.
But I also have to say something that, and I'm sure I've forgotten now, it's senior moments. Because I wanted to say what we have to distinguish. The POPIA provides for exemptions, and that's 37, where you can apply for an exemption to the regulator from one or more or all of the conditions for lawful processing of personal information. If we grant you that exemption, you don't have to comply with that provision. But there is also exceptions, like what I have said, to say that further processing is not allowed, but under exceptional circumstances mentioned in the Act, it is allowed. Then there's exclusion. Exclusion, police, intelligence, they think that they're excluded under Section 6 automatically, and they are not, because Section 6 has a proviso to say you can be excluded as a law enforcement agency from POPIA provided you have legislation that provides adequate safeguards for the protection of personal information. So if you come to us, you are police, the SAPS do not have legislation. They have not adopted legislation that protects personal information, so they cannot be excluded. SAS, South African Security Agency, which used to be called NIA, they also cannot. They came and said, we're excluded. I said, no. If you're excluded, give us the legislation that you have adopted that protects personal information. They don't have. So I want you to look at those three: exceptions, exclusions, and exemptions. Three different things.
Thank you very much, Chairperson. And I think to make it practical for where we sit in our organizations, I'll ask a follow-up question. So when we find ourselves with law enforcement coming to us and saying this, is it prudent for us to then respond on our own? And you've given us the legislation to look at, the areas to look at. Or is this something we can refer to the Office of the Information Regulator?
You can request for guidance.
Okay.
And we are very, the line between providing guidance and giving legal advice is very thin. Because we don't want to give legal advice and then after that, we are in a conflict of interest situation. We can give advice and we'll tell you that this is our advice, it's not binding. You also still have to, get your own legal advice. But we do provide advice, especially on further processing.
Yes.
We get lots of, sometimes you find that SASSA or Department of Social Services, they're looking for people that have benefited from some mining claims and so on. They can't find those people. They come to us to say, can we request this information from this one from the banks? And we normally says, if we think it is for the legitimate interest of the data subject, we say yes, further processing and sharing is allowed. Yeah.
Okay. Thank you. Thank you very much, Chairperson. Thank you very much to our speakers. Your job is not done yet, but we are going to turn to our colleagues who are with us. Colleagues, we've touched on a number of subjects very specific to our guests who are with us, and we're going to open up for questions now. What I will ask is that you put your hand up. We do have roving mics, so the mic will be brought to you. Please ask your question. If it is directed to a specific person, please let us know who the person is and direct your question. Let's try and make our questions as short and precise as possible. Let us try and avoid follow-up questions at that time because we want to make it fair, give everyone an opportunity to ask. What I will also say is, again, this is not the end of our process. As we've seen with our discussion, there are a lot of issues that we can go into and that we need to go into when it comes to POPIA and the practical application for us in our work environments. So we will have further opportunities. Today, we will want to keep it specifically to the topics that we have raised. So I'm going to open up. If we have any questions that we would like to start with, please raise your hand. We have a question here. Thank you. If you could give us your name and organization as well.
Sure. Natasha from Workforce Staffing. Actually, I think anyone on the panel can answer. So it's just something more from an internal perspective. How can you ensure transparency during workplace investigations without having to compromise the investigation and even perhaps, tipping off a suspected wrongdoer in that event?
Great, thank you. I think we will start with that question because I think a number of responses can come, and I'll start with tackling it. So when it comes to our investigations, a good principle to follow is a need-to-know basis. So need-to-know is within your organization, when you receive the information that an investigation has to be initiated, there has to be clarity about why the investigation must be initiated, go through the process of a methodology. With that methodology, it should be clear who needs to be informed and what they need to be informed about. And then it must also be clear who needs to be questioned and what information must be provided to the person you question and what you get from them. We have found that from a basis of investigations, we immediately put everyone on a non-disclosure. So this can be internal persons, external persons, but really to safeguard the process and to make sure that the information that is shared is specific to what's required and only by the people who need to provide it. We make sure that everyone understands that that's the standard that they need to work to. So that's really the beginning of the process. And then in terms of who to share with, again, the organization must be clear in terms of methodology, who the information must go to when the investigation has been conducted, along the principles of who must investigate, who must be requested, who must provide. It must again be clear who the reporting should be to, and it must be as narrow a circle as possible. The principle being on a need-to-know basis and on an application basis, and getting to the point where resolution is met, but it's met in an effective way. So you don't want a process that's compromised by leaks, for example. And by keeping that circle of information as closed as possible, if any leaks do occur, it should be relatively easy to find out where, by knowing who could have possibly had an interest in sharing it. So that's really from a practical investigation perspective, we find that that's the best way to go. But enforcing that seriousness from the beginning, and I think with us speaking about POPIA, people understanding that there's legislation behind this. You cannot just share information. You must not just share information. Putting that in the non-disclosure that must be signed by every person involved will press the point home of the seriousness of not sharing the information and keeping it in. Yes.
You must have a privacy impact assessment. Those, and which will also look at risks of, the type of information that you collect and the risks around that. Because if you don't have this, you won't know even in those investigations, how you're going to apply POPIA. because that previous impact assessment will tell you, and the policy on the issue of minimality.
Yes.
For instance, if information have to be shared, POPIA says you can only obtain the information that you require for the purpose of conducting an investigation. So you'll then have to say how we're going to apply minimality, how we're going to apply sharing of information during the investigation. I think it's important to say that.
Thank you very much.
And
Chairperson.
one other thing.
Yes.
What we have also discovered, which is something that we never thought of, and it comes to the point that you wanted me to talk about,
Yes.
about access to information and POPIA.
Yes.
Because during an investigation, in one case where an employee is being disciplined, then that employee was requesting information relating to the disciplinary process that they were going through in order to prepare for their defense. And the issue became, who does he ask that information from? And he then put a POPIA request to the information officer, who is, because it's a public body, who is the DG. So it's then being sent from pillar to post. The DG says you must ask the chair of the disciplinary hearing. The chair of the disciplinary hearing says, no, I can't give you that information. In fact, that's how it started. The chair said no, and then the employee went to the DG. The DG did not respond because he had referred him back, it was back and forth. So at this point, it is a point where, in terms of POPIA, he has to appeal. And now in the public sector, the appeal goes to the minister. But the information that they require is information relating to the disciplinary process that he's going through. You see how the two things come together and they become complex then.
I have a question, and I think it provoked by Patel when he was talking about what is the approach in terms of breaching employment law and POPIA, right? So I do a lot of consulting with different business stakeholders, right? And there will be sort of queries with regard to department institutions, for example, Department of Labor. They would sometimes send like inspection notices using their own personal emails, using their own WhatsApps, or sometimes they will tell you that, no, you know what, send me this document maybe on my other email, and you're not even sure if this person is really from Department of Labor. I know as employers we do have a responsibility to call Department of Labor and double check if this is the person who's been appointed by the minister. But also, I'm saying this because I was a labor inspector before, and so I know that is something that, especially in government institutions, it's happening. So sort of there's a lack of education, sort of emphasizes more on private than public. And I think, I would like to know in terms of how should we go about that? Because if you don't send them the documents, either way, they're still going to go on with the process and, refer you to labor courts or to statutory services, and that is costing the company. So I would like to know what would be the approach, because yes, we are legally required to send them this document, but at the same time, we as a business, we have a responsibility to protect information of not associates, but information of our employees that we share with that party. So I just want clarity on that. Thank you.
Thank you.
I want to and I'll answer your question directly. Labor inspectors have been the bane of employers' lives for very, very long. So I want to start off there. But I want to just say the following to what the chairperson says. This request for promotion of access to information and disciplinary hearing fortifies the view. Fortifies the view as to the new arena of protection of employment, because this thing here would have probably, especially in the public sector, everyone's scared to do anything. So this disciplinary hearing would have taken 2 years, and then there's a report, and Scopa says, oh my word, you have so many people on suspension, it's taken you so long to discipline, we need to be more proactive. But I'm going to answer your question in a moment. I just thought that was very important, and it highlights the efficiency or our responsibility to South Africa as to South Africa Pty Limited. can I then just say to you, I would be very hesitant to give any of my employee information to a Gmail account, irrespective of whether you're confirming it and the person says that they're going to confirm it. Insofar, and we've had this, COIDA, the Employment Equity Commission, they come and they say, give me. You know, when there was the, and I'll give you a further example, the TERS governance thing. They said, give us all the information. Tell us how, we're busy doing an investigation. And we said, on what basis do we give a private attorney who thinks that he's appointed, we don't have any confirmation that they're appointed, by the Department of Labor to come and investigate us, and they want all of this information? I wouldn't give it. You need to explain to them, and if they insist, the chairperson's here. Thank you, chairperson.
You know why SAP has got into trouble? They were using WhatsApp. Because the information of those sexual victims of sexual assault in Krugersdorp, they shared it among themselves. They were saying that is for investigation purposes. But the information got to a cleaner in their police station, it went to the admin person, then it went viral. So they can't turn around and say, they couldn't turn around and say, Section 6 could not apply to them because they don't have legislation. But secondly, they couldn't say they were sharing this info, it was processing by a public body for the purpose of performing a public duty. Because if you perform a public duty, you don't just, if you investigate, you don't take people's information, put it on WhatsApp, and share it with everybody. So that's why we said we found them to have violated the requirement of consent, because the exceptions did not apply. Using WhatsApp, never go there.
Okay. Thank you very much, Chairperson.
My name is Yondela Ndema, and I work for Palo. So we have a so-called ethics community, i.e. each and every division will appoint an ethics ambassador. So if we have a call pertaining to Cliff Ducker, we'll allocate that call for investigation, let's say to the chair. But we don't know what we don't know. We don't know the foot soldiers that the chair engages in the process of the investigation. So the question or the concern is, how do we then bulletproof to ensure POPIA compliance? We noted your comment about signing of NDAs, but given parties that are involved in the value chain, yes, where do we draw the line? Do we NDA just the first line, or do we say, Chair, tell us who else will be involved when we allocate this call, including ER, including all the foot soldiers in that legal division? Thanks.
That's not for me, I guess. You're the one who talked about non-disclosure.
About non-disclosures. Look, I think it then went to the next level, if I can call it that, where it then goes further. So internally, I think, and which is what we were dealing with on this side, we would then still have it at that level, that we need to get it NDA'd, because we find that that's really the most important way of dealing with it. We do deal external as well, so where you have external parties, we would then hold them to the same process. But that also depends on the policy. So the policy would need to speak about the external stakeholders and what they need to meet in terms of the privacy policies that the chairperson spoke about. So when you deal with your stakeholders, they must be aware of what your standard is as an organization. So do you have the privacy policy in place? Does it speak about stakeholders? Are they clear on how they would need to relate information if they are part of an investigation? So it's really that level of communication. If there is then referral to the Office of the Information Regulator and knowing who else is involved, I'm not sure how that would be dealt with.
You see, if you outsource,
yes,
those consultants will be your operators. So you'll have to have a contract with your operators on how they'll process personal information. But if there is a breach happening at operator level, we come to you, not to the operator. But I think it's important to talk about auditors, because when auditors perform an audit, a statutory audit, they are not operators. They are a responsible party. I think that distinction is important.
Thank you very much for that. And I know we have heads of internal audit sitting in the audience, so that's a very important
Just to
matter.
add as well, you need to have segregation of roles within the organization to understand who plays what within the value chain. So the segregation of duties and segregation of roles is quite important.
Thank you very much. So when we go further with that, and I'll be very quick with that, when the information regulator, so if a complaint then comes and someone lays out that this has now happened and there are a number of role players, how do you then engage with that complaint? Are you interested in everyone in the value chain, and will you communicate with everyone in that value chain?
We obviously get the complaint in such a way where we ask questions. Who is related to these proceedings? What role do they play within these proceedings? What information do they process within within their duties and roles? So hence I'm saying segregation of duties is quite important. You would not want someone from legal, for example, who's processing, or who from compliance, who will be involved within the disciplinary process if they are not relevant within that process. You would not want a cleaner, just an example, to be involved unless they are a witness, but to be involved, or a clerk who processes information that is not relevant to the process as well. So segregation of roles is important. When we look at such complaints, we drill down and want to understand who plays what within the process.
Very important point.
Very.
I think when we deal in our organizations, whoever we involve has to be aware of what the requirements are, their responsibilities as well, because when that search is done, when that tracing is done through the value chain, they will need to speak to the role that they've played, and that segregation and those duties are going to be very important. Thank you very much, Nosipho. The lady in the green jacket, Gugu, please go ahead.
Good morning, ladies and gentlemen. My name is Gugule Tuvelelo, and I work for Clientele. So my question is directed to anyone in the panel, and in the process of sharing information with other parties, I'm just concerned about, have we ever considered the aspect of cyber risks? So if we share information, maybe a document that has an employee's ID, bank account, and so forth, do we password protect it? And have you ever considered, like, when we share that information, do other companies tell us that, okay, we know that cyber risk is very significant and we are aware of it? Do we password protect the document, or we just share the document and that's it?
Thank you very much for that question, Gugu. And Chairperson, you spoke about the challenges of 4IR and what we're dealing with, and cybercrime is something very big in our days. How do we deal with this?
Well, with us, we can't tell you how. The policy has to tell you the policy you have, because all that we're interested in as the regulator is that each responsible party, company, each public body must have adequate security measures in place to protect their personal information in their possession. So those security measures, you have to put them up yourself and see what they are, the ISOs and all those things. Because if you are breached, then we come for you, for sure.
Definitely. And also you have to, in terms of legislation, notify the regulator where there is a security breach. So it's a requirement in legislation.
Thank you very much. We'll take one last question right in the front. I think there was one taken at the back.
Good morning. My name is Mpume from the Gautrain Management Agency. What I would like to ask, and I would like to direct this one to the chairperson of the regulator, is that a point has been made that POPIA requires the data subjects express consent in which the specific purpose for processing of their personal information is specified. So the question is, what would be the most pragmatic way to ensure compliance where getting the data subjects prior consent is not possible, for example, during the recruitment processes or supply chain management processes where we require personal information of referees, but we cannot get the referees' consent to actually have their personal information. Thank you.
I mean, I don't understand the question unless you have.
No,
I think, Chairperson, the thing is that don't appoint the person and don't appoint the supplier. If they refuse to give you consent, that should be a red flag already.
Exactly.
The chairperson has already indicated to you that consent is essential. And if the person refuses, you know they're hiding something, don't appoint the employee, don't appoint the supplier. So I really
Thank you very much.
Thank you.
Colleagues, we're going to draw our proceedings to an end. As I said, this is not the end of our interactions and discussions. A lot still to be discussed. Thank you very much for joining us today. A special thank you to our speakers. Chairperson Nozipho, Roxanne, Adil, thank you for engaging us on very specific topics. And just as a sign of our thanks, we'd just like to present you with a small token of our appreciation from CDH. And we hope it encourages you to join us again when we have a discussion similar to this.
Thank you very much.
Thank you.
Thank you very much.
On behalf of Advocate Boykai.
Colleagues, we have further networking. For those who can't stay, we'll just move back to our room. And if Chairperson still has time, our speakers still have time, we can interact further with them. Please do network, get to know each other. If there's any information that you would like from CDH, please feel free to speak to the CDHers, and we will provide the same. Thank you again for joining us today.
Visions are desires that flicker between a wish and intent. They are carvings waiting for the artisan's hand. One who is consumed by purpose. One who can bring vision to fruition. Cliff Decker Hofmeyer, incorporating Kieti law from vision to fruition.